Okay, three, we're live. 3, 2, 1, 0. Action.
Okay, copy the link and send.
When I live,
How will people get the link?
I'll send it to you now on WhatsApp.
Okay.
And I can link already. That's not
Yeah, I
notification.
understand. If I get to my channel, can I watch it?
Yes, you can.
Very good.
Carry Kasamiko. There's no need sending it to you again.
Turan.
Okay, so.
Only in copying the Turan on the channel. Is the mic picking well?
Okay. Sorry.
Adam, be careful. Can't catch your video. All right, thank you very much. My name is ISHAKU Joseph Shirimai. I'm the host of ISHAKU Legal Hub. It is our pleasure to have you today. We will be discussing a very, very interesting topic, alternative dispute resolution. We call on you to kindly subscribe to this channel, follow our discussion. It's going to be very, very interesting. We have one of our finest seasoned legal practitioner who is a very, very competent person in this field that is going to discuss and share light on this topic. You're going to learn a lot here. Send your questions, send your comments, we'll view it and we'll respond to you. So you will be meeting our guest now. So you're welcome, sir.
Thank you.
Can you tell us your name? Let's know who you are, sir.
Okay, my name is Farouk Kemiel Kamagam. I'm a legal. I run a practice called Brooklyn Law Chambers.
Okay.
We're into general practice, but we're also very proficient in arbitration and alternative dispute resolution. In that regard, I am a member Chartered Institute of Arbitrators in the UK.
Okay.
I am also a proficient dispute resolution specialist, DRS.
Dispute resolution specialist. You are most welcome, sir. So we have
Thank
been
you.
hearing this issue of alternative dispute resolution. What do you want us to know on alternative dispute resolution? Is it a better option? What is it? Let's understand this alternative dispute resolution.
So first of all, let's start from the basics. Alternative dispute resolution is about conflict resolution.
Okay.
Now, what is conflict? As far as we have human beings on this planet Earth, there is certainty of conflict.
All right.
Conflict takes place in different places in different forms. If you go to the home, you may have conflict between husband and wife. If you go to the office, you may have conflict between a boss and a subordinate.
Yes.
If you go to government offices, you have conflict among colleagues sitting in the office. If you go to, as a businessman, you may have conflict with your customers, conflict with your business associate. So anywhere you turn to in this world, in pursuit of your legitimate livelihood,
Yes,
there is always the certainty of the likelihood of conflict in the process of that transaction. So if we are certain that conflict is a natural part of human existence, the question then is, how do we resolve that conflict?
That is the issue. How do we resolve this conflict?
Good. So this is the point where the idea of ADR came in. Because the most conventional method of dispute resolution that people are aware of is the court system. So anytime there is dispute that arises between business associate or partners, we go to court. Dispute arises between husband and wife, we go to court. Dispute arising between employer-employee, we go to court. Then over time, we realize that, is it actually necessary for us to continue to go to court on every single dispute that arises? Are there not other alternatives to this court system? Now, why must we continue to go to court with it attendant some of the disadvantages of going to court, which we will discuss shortly?
Okay.
Can we find an alternative to this court system? Now, this is where the idea of ADR came in. A means alternative. Alternative to what? Alternative to the court system.
Oh.
So this is why we have ADR, alternative dispute resolution, meaning how the method of resolution of dispute outside the court system.
Okay.
That's right.
So you mentioned the disadvantages or advantages. We already have the court in place. We
That's
know
right.
that when you have a dispute, you go to court.
That's right.
And then you are talking about alternative. Why
That's
do we
right.
need an alternative when the courts are there? Are the courts no longer relevant?
Well, it's not that the courts are not relevant, but we know that for everything, there are two sides of the coin. Now, the court system have their advantages, but they also have their disadvantages. Now, one of the famous disadvantages of the court system, especially in our jurisdiction here in Nigeria, is that cases often take too long to start and finish. So you have a situation where people go to file case in court, and then you have the lower courts, you have the appellate courts. And
Okay, what's the lower court?
Lower-
Let's understand. We are not lawyers.
Exactly. Okay.
Thank you, sir.
So lower court are the courts that at the lower level from where dispute resolution begin. At the lower level, we have courts like area courts, we have court like magistrate court, we have courts like high courts. So depending on the nature of the dispute, one of these court will certainly start the resolution of this dispute before it go to the appellate system.
Oh.
So these are the court we identify as the lower courts. Now, we have situations where our courts are congested because of too many cases that have been filed in the court. Now, sometimes we blame the court and blame the judges for cases staying too long in court.
Okay.
But people need to understand that the courts are not magicians. The judges who sit on those cases are not magicians. They are human beings like us. They get tired like everybody. They have families to attend to. They have other things to attend to outside the court. So when you have a judge having 500 case files, it is natural for you to expect that cases are going to stay long in that court because you need to attend to all those 500 cases.
Wow.
So this is why when you go to Supreme Court today, you find cases that they are attending to cases that are as far as 2002 cases still pending at the Supreme Court. From 2002 to 2023, how many years? This is how long cases can stay in court. We have had cases where at the Supreme Court level, now both the plaintiff and the defendant are both dead, but the case is still alive at the Supreme Court.
Wow.
They have not lived to enjoy the outcome of the case they filed in court. So this is how long cases can stay in court. This is one of the major disadvantages. Then one of the other disadvantages is that our courts are court of laws and rules.
Yeah.
Sometimes those laws and rules are inflexible. So because of those technicalities, they also contribute to cases staying long in court without being resolved amicably.
Okay. They are court of laws and rules.
That's right.
You know, you are a specialist. Can you break it down so that we understand what that means?
All right. So what I mean by that is that courts are established by laws. And when courts are established, they are established for specific purposes. And for the purpose of achieving those purposes, we have rules that guide the court in conducting those cases before them. And any case you bring before the court, it has to pass through those rules. So how you file your case, whether you go by originating summons or by writ of summons or by other means of commencement of action, you have to follow what the rule says. If you don't do that, it becomes a problem to the case. The other party will raise preliminary objection. Now, you have left the merit of the case. You have to settle the issue of rules first, whether or not I brought this case in accordance with the rule of court. So this is what we mean by that courts are courts of laws and rules. They have to adjudicate those cases in accordance with the rule, applying the relevant laws to those rules. So sometimes those laws and rules are inflexible. You just have to abide and comply with the provisions of those laws and rules. So those contribute to the technical nature of how disputes are being resolved in the court system. And those also contribute to why cases stay long in court without being resolved.
Okay. Because these laws has to be followed.
Exactly.
So in this alternative dispute resolution, are there no laws? Are there no rules?
That's an interesting question. There are rules. There are laws and there are rules, even in alternative dispute resolution. But here is the difference. The laws and rules that are made for alternative dispute resolution make alternative dispute resolution so flexible. They are not as rigid as the one that apply in the court system.
Okay.
So it gives you the room to manipulate or abridge some of the technicalities that are applicable in the court system. The laws and the rules in alternative dispute resolution try to sieve away those technicalities and complexities so that you are able to reason not the same thing with the court-connected system of dispute resolution.
That's strange. So now you mean if I go to meet my lawyer, instead of insisting on going to court, because that is what we know. You are a lawyer, for goodness sake. I come to meet you, I have a case. Which one is settlement? Which one is alternative? Let me go to court and see my lawyer talking in the court. Now, this is my own idea. And then you are bringing another idea. How will you convince me on this?
All right. So here is the thing.
Okay, sir.
When you go to court, you are looking for something.
Yes.
That thing is called justice.
Absolutely.
Now, as a plaintiff, you hope that at the end of the day, you will get judgment in your favor. As a defendant, you're hoping that at the end of the day, the court will dismiss the case of your opponent. That means the judgment is in your favor.
Okay.
But we are saying that you don't have to go through that route. You can achieve that same justice without going through the court process. So what you are looking for in the court, you can get it outside of the court, but it is also as effective as the one you got from the court system. So here is the reason why, but this is even the more reason why. Outside the court, you will get it more cheaper, you will get it more faster, you will resolve the dispute still remain friends.
That cheaper is very interesting for me. We are in a situation where we have to be cutting costs.
Exactly.
We have to be looking for the dollar now and the situation of the country. So how is it cheaper? Let's understand so that next time I'll be able to weigh my options very well.
Well, to be candid with you, some of the methods that have been in practice so far in ADR are also becoming a bit complex and also costly.
Okay.
But by and large, generally, the amount you spend in resolving your dispute out of court are usually lesser than the amount of money you spend in filing your cases, paying your lawyers. On each day they go to court, on each day you go to court, you need to transport yourself. Now, all those costs, when you count them now, when a case stays up to 10 years.
Interesting.
And at the end of those 10 years, when judgment is given, you count how many times you went to court. You have to fuel your car. You have to pay your lawyer also to fuel his car. In those 10 years, you have filed court processes how many times? In each of those processes you file, you have to pay money to file those processes. Now, by the time you realize you would have spent a lot of money pursuing justice, and at the end of the day, you may still feel not satisfied. You may have to exercise your right of appeal by going to the Court of Appeal and up to Supreme Court. In those processes too, you will spend more money and in some cases even higher than what you spend at the lower court. So when you count those costs, those financial costs, and compare to what you will spend in resolving your dispute out of court, you realize that alternative dispute resolution gives you a cheaper alternatives compared to going to court to resolve your matters. This is why we say sometimes they are cheaper compared to the court-connected system.
Wow. You said something that got my attention. You mentioned sometimes cases can stay in court up to 10 years. Really?
That's right.
Wow.
So
10 years.
So I have an example. Okay. We have a case currently pending at the Supreme Court. In fact, because of the nature of that case, we had to seek the leave of the Supreme Court to file the appeal. Now, we filed a motion on notice for leave to commence the appeal itself.
Wow.
Now, that motion was filed in 2017. But guess what? We were only able to move that motion in July 2023.
5 years.
5 years. It took us 5 years to just move the motion for permission to commence the appeal, not commencing the appeal itself. So now, after getting the leave, we have to file notice of appeal, we have to compile record and transmit record, and then we have to file brief of argument, and then the worst, getting a date to be heard at the Supreme Court.
Is also another issue.
Is also another issue. Now, this is at the Supreme Court. In the High Court, where I told you earlier that you may have judge having up to 500 case files, and he has to attend to each of those case files. And in each of those case files, you may find, apart from the case itself, you may find preliminary objections, application for extension of time, other extraneous applications that will distract the court from attending to the main issue. By the time they resolve those issues and come back to those issues, you're talking about 5, 6, 7, and sometimes up to 10 years. You are still on the matter. So, unfortunately, our court system, we have found ourselves in this kind of situation where cases stay up to that length of time, yet to be resolved.
I told you our guest, Kemi Al-Farouk Kamagam, is a specialist in this area, and by now I'm sure you are also convinced that he is well acquainted with the issue of alternative dispute resolution, and he's bringing up serious issues that we don't even know. So cases can stay up to 10 years in court, and this is one of the reasons why alternative dispute resolution is here to help us. He mentioned another interesting thing for me, especially when he mentioned that this process is cheaper. Very, very interesting, and I think is a good thing to do. So please, we care about you, we care about your comments, we care about your questions. We appreciate your comments, we appreciate your response, and you can drop your questions in the comment section. We will do well. We're seeing your questions and we'll respond to you. Don't forget to subscribe to this channel, share this link so that other people will learn from this specialist. Now, the question, sir, is it every form of dispute that can be resolved through alternative dispute resolution, or there are issues that cannot come under alternative dispute resolution?
So that's another interesting question. Now, a straightforward answer is that not every case is susceptible to alternative dispute resolution.
Okay, not every case.
Yes.
Okay, so maybe we'll take the question in sections. Can we start maybe by listing and giving us examples on issues of disputes that can come under alternative dispute resolution?
Okay, that's fine. Now, if you have cases such as matrimonial matters are dispute between husband and wife as to their marital relationship. These issues can be resolved using alternative dispute resolution, except when it has to do with the dissolution of a statutory marriage. Now, in that case, it is only a competent court of law that can dissolve a marriage. But all other issues or disputes surrounding or connected to relationship between husband and wife can be resolved using ADR. Secondly, disputes that are connected with employment relationship.
Yes, sir.
such as trade dispute, such as employment, unlawful termination of employment, such as wages, such as other, dispute connected to labor and employment relationship. Those cases can also be resolved using ADR. Now we have also business relationships, contract relationships, contracts such as supply, such as services. Okay. Now, when you have dispute arising from those kinds of business relationship, those kinds of dispute can be resolved using ADR. Now, in fact, just to say that most kind of dispute, 90 out of 100 type of dispute can be resolved.
That is what I started getting when you started listing all these things.
ADR, yes.
They are largely part of the disputes.
Exactly. What the law has done is that it has tried to enable ADR to reach almost every aspect of human relationship. Now, even the criminal cases that we used to say ADR is not applicable, you find that nowadays there are aspects of criminal cases that you can apply ADR. And that is why our police institutions are being trained on how to resolve petty cases that will be reported as criminal cases. These are ADR in action. So ADR is applicable to almost all aspects of dispute, with the exception of very few.
Wow.
Yes. So I would prefer to list the exceptions than those that are applicable, because almost all are applicable. So it is better for us to list the ones that ADR cannot apply, because these are the exceptions and these are the ones that are fewer.
Like I said, he is the specialist. So he is going to take us through some of these cases, some of these disputes and misunderstandings. Questions are coming in. We'll take your questions and we'll keep on responding to them while he continues to answer our questions.
Thank you. Now, like I mentioned earlier, in criminal cases, when a case has to do with murder, fraud, and other major crimes, those crimes can only be resolved in the court system, because nobody has the right to declare another citizen guilty of an offense. Our constitution says it is only a court of competent jurisdiction that can declare a human being who is charged with a criminal offense guilty of that offense, especially those major offenses. Now, so in certain criminal cases, ADR will not apply.
Okay.
Now, again, when it has to do, I also mentioned earlier that even in matrimonial causes, now the law also says that it is only a court of competent jurisdiction that can declare a statutory marriage dissolved. Statutory marriage is a marriage that was conducted in accordance with the statute. In Nigeria, that statute is called the Marriage Act. So once you conduct marriage in a court registry according to the Marriage Act, that marriage can only be dissolved by a court of law when there is a dispute. But if that dispute has to do with custody of children, has to do with conjugal rights, then those aspects of the case can be resolved using ADR.
Okay.
But if the question is whether that marriage can exist or not, then it is a court of law that can declare that this marriage no more exists or it has been dissolved.
Okay, you just mentioned a marriage that I'm not very conversant with. You say marriage in registry or what?
Yes, it's statutory marriage.
Statutory marriage.
Now, the name used in common parlance is court marriage.
That is what I was getting off balance. Court marriage is the one we know.
Good. So the correct name is statutory marriage, because actually there are no marriages in court. Court don't conduct marriages.
Wait. Did you hear what he said? Don't be giving us too much. We have been raised to know there is court marriage. So you mean there is no court marriage? Court don't conduct marriages?
Technically speaking, there is nothing as court marriage. Like I said, courts don't conduct marriage. You conduct your marriage at the marriage registry. Some at the local government, some there is federal marriage registry. If you are in Abuja, you may be aware that there is marriage registry in Amak area 10 or the federal marriage registry. These are where you conduct marriage according to the Marriage Act. When it goes to court, it is when there is problem with that marriage and that marriage need to be dissolved. This is where the court get involved.
Wow. I hope this is part of your takeoff. This is just a kind of, by the way, you have learned that there is nothing called court marriage. It's marriage under the registry. So we have a question from News TV Studio. The question is, why does the court really encourage people to engage in ADR before attempting to file a case? Or in other way, does the court encourage people to explore this alternative dispute resolution? Or once you come before the court, then you are before the court?
So, two things.
Okay, sir.
First of all, before you come before the court is not aware that there is a dispute between you and your partner.
Okay.
At that stage, only you can determine whether you want to go to court and resolve that dispute or you want to resolve the dispute among yourselves.
Yeah.
But at the point you come before the court has already assumed jurisdiction over your dispute. But even at that, by the law establishing most, talk about the High Court, talk about the Magistrate Court, talk about the Court of Appeal, the law establishing these court institutions mandates them to encourage parties to settle their cases out of court, if it is possible. So even when you file your case in court, that does not stop parties from using ADR to resolve their differences. And where parties have indicated interest that they want to attempt to resolve their cases out of court, the court is mandated by law to allow parties explore that ADR option. Now, when it works, they can come back before the court and tell the court they have settled. Now, they can do two things at that point. Either withdraw the case from the court, or they can enter what they have agreed on in the ADR before the court and ask the court to sanction it by entering it as a consent judgment.
Wow.
So, but either way, the simple answer is that courts are meant or designed to encourage parties to apply ADR in resolving their differences, because it's in the interest of the court itself. When parties resolve their dispute amicably, this is one file off the docket of the court. The court can now use the time it would have used to settle that case in settling other cases pending before it. So, from experience, indeed, our courts, especially in FCT where I practice, I have seen court encouraging parties to adopt ADR to resolve their differences. And they are permitted by law, not just permitted, but mandated by law to encourage parties to adopt ADR.
Wow. So you mean even the courts advise litigants before it to explore settlement?
Exactly. That's what we are saying.
This is very, very interesting. And for some of you who are just getting to know new information like this, come with some apprehensions, questions, and doubts. If you have any of these, please drop it in the comment section. We will be willing to do justice to it. We have a specialist on alternative dispute resolution, Mr. Kemi Alfaru, the senior partner of Brooklyn Law Chambers. He is here to do justice to all our questions. Please explore this time. There's a free consultation for you. All right, Mr. Farouk. The next question we want you to address for us. This issue of alternative dispute resolution, is it a new something or it has been there all this while?
So, ADR is not new.
Okay.
Yes, that's a straightforward answer. In fact, before we got to the conventional court system, ADR has been what was obtainable in the days of our forefathers. If you're an Igbo man, for example, you will recollect the village council, where issues in the community go to for elders to look at it and resolve dispute among family members in the community. That was Adar in action. If you are a Hausa man, you remember those days our fathers used to go to Mai Palace. All disputes are taken to them, who look into it and help parties to resolve their differences. So as long as human history exists, Adar has been in existence. Now, the problem was that when the conventional court system came after colonialism, our attention shifted to the conventional court as if it's the only place to resolve dispute. We neglected what we had from our traditional history. And so what happened also may interest you. The Europeans and the white men, when they colonized us, they studied our system. And they realized that this, our traditional system of dispute resolution, can be modernized and be still useful in dispute resolution, even in the present day society. So they went and modernized it, and they brought it back to us with the name Adar.
Giving it English name.
Giving it English name. And people begin to, what is Adar? As if it's a new thing.
Very interesting. So it is our own system that the colonial masters picked up from us, modernized it, because this has been as long as our existence.
That's right.
I can remember back then in secondary school or primary school, when your teacher settles issues between you, you'll be forced to check the other person.
That's right.
That is alternative dispute resolution in action.
That's correct.
So it is not really an entirely new system. It is just modernized. So there is nothing to be scared of. There is nothing to be afraid of. Alternative dispute resolution is part and parcel of us. It's our own system. It's not the creation of the white man. Now, we have a comment. Well, he said on the lighter note, so I'll read it as he says in the lighter note, that from becoming a filmmaker, he said, I must say that the federal government and its citizens needs this ADR. The federal government and its citizens need this ADR. Okay, thank you very much, becoming a filmmaker, for your comment. Another person says, you are right, barrister. Our forefathers practiced a lot of LD laws than this time. Very, very interesting. It has been like that. Now we're taking another comment. This is a question, sir, for you.
Okay.
This question is coming from Dabish Nankar. We thank you for your question. Who pays for the ADR?
All right.
Who pays for the ADR? If you're going for ADR, who pays for it?
So, depending on the method of ADR you have adopted, which we have not talked about yet,
Okay.
there are different methods of ADR.
Okay, maybe you will take time to tell us these methods and who pay in which.
All right.
All right.
So, now ADR take different shapes. It can be in the form of negotiation. It can be in the form of mediation. It can be in the form of conciliation, or it can be in the form of arbitration. There are others, but I will just focus on this four.
On this one, okay.
Now, when you talk about negotiation, negotiation is a method of alternative dispute resolution, where parties, having identified that there is a dispute between them, try to sit down, talk to each other, negotiate their terms, and agree on how to resolve that dispute among themselves without the intervention of any third party.
Okay.
Now, by the time they're able to do that, they would have resolved their differences using negotiation. So if I have a business relationship with you, and then I paid for goods, you didn't deliver to me at the time I asked you to deliver to me, there is a dispute. But instead of going to court, we decide to say, come, what is the problem? Why have you not been able to deliver? Oh, sorry, I have already booked for your good, but because there was an incident along the road, the car broke down, or there was an incident, that is why we found it difficult to deliver. Okay, when are you delivering? Let me explain. This is negotiation. Now you arrive at a new term agreeable to both parties, and that dispute is resolved. Now, when you adopt that method, you see that talking about finance is even very
no cost
negligible. Yes. The only cost you may incur is the cost of having to transport yourself to where you will meet and do the negotiation. But really, everybody bears that cost for himself. Now, but there is another method of dispute resolution called mediation. Mediation is a form of ADR, or alternative dispute resolution, where both parties to the dispute willingly submit themselves to the aid to resolve their differences using a third party.
Okay.
Now, but that third party does not have the power to give a binding decision resolving the dispute between parties. The role of that third party is to help the parties to resolve their differences. So that third party, called the mediator, meet Mr. A separately, knows what are his problems, what are the point of contention in that dispute,
his grievances,
also go to meet the other person, know his own grievances, then try to advise them on how they can amicably arrive at a consensus among themselves. This is how the dispute is going to be resolved, and both of you must take it. No. He just helped part of communication, in terms of strategy, in terms of advice. This is how I think you can resolve this dispute, and both of you will be happy for it. Now, when you adopt that method, then certainly there are costs to be incurred. In a formal mediation setting, you will have to hire that third party you are submitting to help you resolve their differences. And because he's a professional, he's going to charge you his fees. Now, you among yourself will have to agree how you are going to raise this money and pay that mediator.
Okay.
So in most cases, is maybe a 50-50 something. So if the fees for the mediator is say 100,000, both of you may contribute 50,000 to pay him for his fees, or any formula you may agree on to contribute. So it's going to be a contributory system in setting up the cost of the mediation.
Okay.
Then when you adopt a method called arbitration. Now, arbitration is the most formalized form of ADR so far.
Okay.
Because it is mostly used in international commercial dispute resolution, or adopted by multinational companies, because, I mean, like we said from the beginning, time has passed. Businessmen want to resolve their differences and move on, not wasting years in court. So most serious commercial agreements usually have arbitration clauses included in them. Now, in those formalized arbitration settings,
yes, sir,
the arbitration agreement also specifies who pays what. Now, in that method of dispute resolution, you also subject your dispute to a third party called the arbitrator. It may be a one single arbitrator, or 3-panel or 5-panel of arbitrators, depending on what you agree on as to the number of arbitrators. Now, those arbitrators are going to also charge their fees because they are giving you professional services. They are going to sit like the judges to resolve your case, and they are going to be paid for those services. So the arbitration agreement also specifies who is going to bear that cost. In most cases, you realize that the party who loses is most likely going to bear the cost of the arbitration proceedings, because it's going to be awarded as cost.
Okay.
Now, what happens is that both parties are going to contribute the money to pay the arbitrators for their services. But after the arbitrators have done their job and they have given their judgment, usually called awards, they are going to also specify that the cost incurred by the party who wins the case is going to be compensated by the party who loses. And so he's going to recover the cost he contributed in paying them through the cost awarded in his favor against the party who loses.
Wow.
So in that case, you may see that although both of them contributed the fees, but at the end of the day, one party will end up bearing the cost.
Okay.
Except the arbitration agreement between the parties says, regardless of what happens, we have agreed to contribute so X amount of money to pay for the services of the arbitrators.
Yeah.
In that case, that is what will happen.
Thank you very much for this elaborate explanation. What we pick from here is that who will bear the cost depends on the method of alternative dispute resolution that you adopted.
That's
and
right.
Obviously, from the way you are explaining, some of them, the cost will be higher than the others. If I were the one, I would go for negotiation, where my cost will only be the cost of, in his word, transporting myself to the point of negotiation, or at most make calls.
That's right.
Yes, thank you very much. Or at most, I can even go for mediation,
That's
where
right.
I have the mediator, just one person, we do 50-50. Benny, everybody will rest. Thank you very much. Becoming a filmmaker, we made reference to your comment without calling your name. He's the one that said the federal government and its citizens need this alternative dispute resolution. We'll keep responding to your questions as you are dropping them. Now, sir, let's talk about practical happenings.
That's right.
We know it's against your ethics to discuss in detail the cases you are handling or the cases you have handled, especially mentioning names. But can you give us example and instances in a way that is still safe? How successful is this issue of ADR? In real sense, how have you done a few? Were they successful? You give us narrations or just examples for us to know.
So, in my few years of practice as a legal practitioner and as a dispute resolutor, we have had quite experiences in this ADR business. And I can tell you that out of 100% of the cases we have handled using ADR, 99% of them have been successful.
Great.
It's only in 1% that we have to still go back to court to resolve those disputes. So I can tell you that ADR is very successful in Nigeria. In 2019, we had an arbitration between two parties, two oil companies, one in Port Harcourt and one from Lagos. And I can tell you that it took us barely 2 months. We used arbitration then, and it took only 2 months for us to finish our pleadings and hearing of the case.
2
Just
months.
2 months. I can bet you if that case was in court, the minimum we could spend in court will be 3 to 5 years.
That 2 months from the filing of the case, I don't think you will have gotten a day for mention.
Exactly. That is if you are using the court system. But in that 2 months, we have finished the trial and the arbitrators have adjourned to give their awards.
Wow.
So this is how successful and timely ADR can work for you. In many matrimonial cases, in fact, in some cases, they come to me in the office wanting us to go to court. But as a legal practitioner, who is also an ADR practitioner, we are always advised and encouraged by the law to open parties to the possibility of ADR. They usually will buy my idea, let's try ADR. Matrimonial cases that use, we just call me as my client, sit in my office, we talk, and the parties you see at the end of go back home in the same car. This is now we have many other examples of how we have used ADR. Now I give you the most recent one.
Okay.
I had a client who came to me and wanted us to sue his employer. I didn't do anything wrong. So the simple question I asked him is, so if we take your employer to court and the court gives judgment in your favor, will you be comfortable sitting in that office working under a boss whom you took to court? Do you think the working environment will be conducive anymore? And he looked at me and he said, what do you mean? I say, instead of going to court, what if we engage your boss? Talk these things out and see if we can resolve it. And he said, well, if they can hear you, no problem. I'm not sure they will hear me. And like joke, we engage the boss. I call the boss, introduce myself. I'm so from so. I have so person who had laid this complaint, and we feel we want to hear from him first and know his own side of the matter. And he said, thank you. So you see, he jumped at that method because we didn't call him to castigate him.
Yeah.
So he bought into the idea. We fixed a date, and before you know it, he is back to the office today as I speak with you. This is what ADR can do for you. So I have many examples to give to you how we have successfully used either mediation, negotiation, conciliation, or arbitration in resolving dispute. And these have usually worked out. Like I told you, in 100%, only 1% had to go to court.
Interesting. This is really good. We need to explore this issue of ADR. So you as a lawyer, wouldn't your client feel you are scared of going to court, or you are not competent in court if you advise them to settle the matter?
Very interesting. We have had a few clients who are very interested that we go to court. You see, some of the things that make clients believe that a lawyer is working for them is when they see a lawyer in court arguing with the judge and with the other party on their behalf.
Yes.
They feel that you are doing your work. But I mentioned earlier in the introductory remarks that those things you are looking for in court, you can achieve the same thing without necessarily going to court. What you are looking for in court at the end of the day is justice.
Yes.
If you can get that justice without going to court, is it not easier for you?
It is.
Is it not cheaper for you? So we have had quite a few clients who have had that misunderstanding. In those cases, we have to sit them down and make them understand that the fact that we are trying to resolve this dispute out of court does not mean that you don't have a good case. It doesn't necessarily mean that when you go to court, you cannot win. It doesn't necessarily mean that if you go to court, you will win. But what we are saying is that you can get that same thing you are looking for in court, out of the court. This time around, cheaper for you. This time around, more faster for you. And it has the same result that you will get if you had spent years in court.
Wow.
So this is how we get to convince some of our clients to agree to using ADR to resolve their differences.
Very interesting. Thank you so much. I've promised you at the beginning that this session is going to be very interesting, very educating. And I'm sure I did not fall your hand by saying that, because our guest did justice to all our questions. He has enlightened us. And if you agree with me, then give us a thumbs up, give our guests a thumbs up, drop your comments. Don't forget to share this link. Don't forget to subscribe. And to our guests, we appreciate your coming. Any final words on the issue of ADR as we come to a close?
So my final comments will be that don't be afraid of ADR. Don't think that ADR is lesser than the court system. We know that the court system is the formal system, but ADR is also as effective as the court system. One thing that ADR does for you is that it helps you to resolve your differences and still remain friends with your opponent. That you cannot achieve in the court system. In the court system, we have a system where we call the winner takes all. By the time the judge gives judgment in your favor, the other party feels, cheated, and then he resolves to go on appeal. But when you resolve your dispute using ADR, you are able to resolve the dispute and still shake hands and business continue. So ADR is effective, ADR may be cheaper, ADR is faster, ADR is the way to go in a globalized economy. Trade across border, businesses, you are staying in Nigeria, you are doing business with people in other countries. ADR is the way to go in resolving dispute arising of those businesses, because that is the way the world is going to now.
Thank you very much. Sorry, I said in rounding, but we have a question that we need to take. This will be the last question, sir. I know you're very busy. You have made out time out of your tight schedule. We'll release you soon. But let's take this last question from Evelyn Enoch. Please, do parties need counsel to represent them in arbitration?
Yes and no.
Okay.
In more formalized arbitration proceedings, parties too still retain lawyers.
Okay.
It depends on the complexity or simplicity of the dispute that is being resolved using arbitration.
Okay.
So if it is a minor issue, okay, let's say, for example, if it is a landlord-tenant matter, parties may decide to just go to arbitration without lawyers. But if it has to do with complex, business transaction, then it is advisable that parties still retain lawyers. Because like I said, even in the arbitration proceedings, there are certain technicalities that only lawyers know that and can apply it in your favor.
Thank you very much. I hope, Evelyn Enoch, you're still online and you have gotten response to your question. Is not in all cases. In some cases, you will need lawyers. In some cases, you will not necessarily need lawyers. Thank you very much. Thank you, sir. You can still watch this session on our channel. You can still share the link for other people to follow. We hold live session every Wednesday to make sure we enlighten you on different subjects of law. Our focus at ISHAKU Legal Hub is bringing you enlightenment. We don't want you to be ignorant of the law. We don't want you to be ignorant of the procedures of law in Nigeria generally. Thank you very much for your time, and we'll see you in our next session. And don't forget, we drop videos every Wednesday and Friday, and we have our live sessions every Wednesday. We'll see you all the time. Thank you very much for your time.
Oh.
Aboki. Thank you. We'll go this to say. Arebo, thank you for drawing my attention to that last question. Now, your wife, if we don't take that question, we will chop off my head. When I share that, the system now disconnected. No, I get you like a duba mana connection. Career mana lima. But then Sheba, may I say my system now along the way? Na kaman ko data ko Wi-Fi ne ko mene ya kamar at a point your system was frustrating you yadda kin rufe komai kin zauna haka kin fara juya kina kallon mu nace to system naki akwai problem kenan.